The powers of the federal judiciary are granted in Article 3 of the United States Constitution, but have been expanded by the U.S. Congress since its inception. Courts authorized by Article 3 are served by judges called Article 3 judges. The Supreme Court of the United States was the only court originally created by Article 3, though the Constitution granted Congress the power to create inferior courts. The Supreme Court of the United States is the final arbitrator of disputes in the U.S. It is the last court to hear appeals of lower court cases, but has original jurisdiction in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. The Judiciary Act of 1869 set the number of Supreme Court justices at 9. The United States Circuit Court of Appeals hears appeals from the district courts within its judicial circuit. There are 11 circuit courts, plus the federal and D.C. circuits. This level of court was created by Congress in 1891. The number of judges serving on each court varies according to need, though the number is fixed. The District Court is the federal court of general trial courts of the system, hearing both civil and criminal cases. There are 94 district courts spread across the nation. Each district has at least one courthouse, and the number of judges assigned to the court varies by need, though the number is fixed. The bankruptcy courts are special jurisdiction courts, but are unique in that there is one associated with each district court. Judges are appointed to 14-year renewable terms by the circuit judges in which their court is located. The territorial district courts of the U.S. Virgin Islands, Guam, and Northern Mariana Islands have the same jurisdiction as district courts, but are not Article 3 judges. Most notably, they only serve 10-year terms. In addition to the Article 3 courts, there are several special jurisdiction courts. These specialize in a range of issues from international trade to foreign intelligence to military appeals. Of the special jurisdiction courts, only the Court of International Trade was established by Article 3 of the U.S. Constitution. Almost 1,700 judgeships are authorized for the federal courts. This includes SCOTUS, circuit, and district court judges, and part and full-time magistrates. Custom dictates that when a vacancy occurs on a district court, the U.S. senators in that state recommend potential nominees to the President of the United States. The President nominates a judge to fill the vacancy. Next, the Senate Judiciary Committee conducts a hearing with the nominee, then votes on the nomination. If the nomination clears the committee, next the full Senate will vote on the nominee. If the nomination is rejected or not voted on in committee before the end of a term, the nomination is returned to the President. From there, the President can decide whether to renominate the judge or start the process over again. Article 3 judges are appointed for life terms, and there is no mandatory retirement age. Non-Article 3 judges, such as magistrates, bankruptcy court, and special jurisdiction judges, do not follow that confirmation process. Rather, they are appointed by the judges of the Circuit Court of Appeal of their jurisdiction and serve a renewable term.